In view of the discussion, reason, and determination made herein above, this court is of the unhesitant view that the appellants are entitled for benefit of doubt. Accordingly, they are acquitted from the charges, granting them benefit of doubt. Accordingly, impugned judgment dated so passed by learned additional session judge FTC Nagaon in session case number 154 and 2006 in set aside and quas. Bail bond stands discharged.
Right.
Yes, next case.
May I please, your Lordship?
Yes.
Lordship, I beg to mention item number 6, Lordship. Lordship, matter become infectious, Lordship. So kindly may to
Revisal
allow
of
to withdraw.
Huh?
Yeah.
Withdraw.
Withdraw.
Okay, MS
JP Mode.
Mr. JP Moore, learned counsel for the petitioner submits that this matter has become infructuous. Accordingly, the same may be closed.
Obliged, Lordship.
Mr. S. C. Kal, learned standing counsel for
ROC.
ROC also supports such contention. Accordingly, the writ petition shall dismissed being being infructuous.
Obliged.
May I please, Your Lordship, I beg to mention item number 7 of today's list, my lord. I've
Mm.
already informed the petitioner. He is for the petitioner. Kindly
Petitioner, Lordship.
taken up after 3 weeks, my lord.
What is the issue here? Mining, it's closed.
My Lordship, matter may not survey, Lordship.
Not may not, it is not surviving.
Lordship, so we need some instruction, Lordship. So
These
kindly allow.
these mines are not closed. This was an apprehension. Is not it?
Lordship.
There is no interim
but-
order.
Uh,
There are new policy of the Union of India, how to deal with this. What remains unnecessarily?
says I need some instruction from the.
What
petitioner.
instruction tell us?
The whether matter, because matter is year 2020, Lordship. So
That's
we have no
why
communication with the petitioner, Sir, Lordship. Sometime.
you will not have any communication because this was their apprehension that mining in those areas will be closed, therefore they have come. There is no interim order. Interim mining is continuing. Okay, interim mining is continuing. Union of India has taken some policies which has not yet been, if they are new fresh of cause of action, you can come, we'll close it. Is not it, madam?
Yes, my lord.
Yes, give the file. Item number, wait for your turn, just wait. We'll
Lordship.
pass this order. In the meantime, you have instruction. Yes,
May I please, Your Lordship, my lord,
Yes.
the concern of the other side, my lord, I beg to mention item number 18, my lord. I need 1 week time to file my rejoinder, my lord.
item number,
18, my lord.
okay. This is the adjournment slip was given yesterday, okay. Learned counsel for the petitioner pressed for and is granted. To do what?
Rejoinder, my lord.
3 weeks time to file rejoinder affidavit. Yes,
And there is an interim order, my lord.
interim order pass earlier shall continue till the next date of listing. Give a date. Please, this matter, I believe. fully.
May I please, your Lordship? I
Huh?
wish to mention item number 21.
Oblige, Your Lordship.
21.
Here, Lordship, I have received comments, instruction from the authorities. I pray for 3 weeks time to file the.
Is it not covered by the judgment delivered by this court?
And they have given an instruction, Lordship. I would
Any
like to bring on the-
appeal is preferred against
Till
the
date, no.
judgment? Not yet. Okay, Mr. Chaudhary, B. Chaudhary, learned standing counsel for taxes,
taxation. Fine.
Standing counsel for finance and taxation submits that his instruction is not complete and therefore he will require 3 weeks time to complete his instruction. Prayer is allowed, list after 3 weeks.
May it please the lordship, lordship with the consent of other side, lordship, item number 4, maybe adjourned for today only, my lord. We have some difficulties today. I am for the petitioner, my lord. It can be taken up any other day, lordship.
So, there is a procedure prescribed, isn't it? When a license is suspended, there is a procedure prescribed. We'll send that to the authority. Can we decide whether there was a rice of 25 kgs, whether you have sold 75 kgs, total was 120 kgs?
My lord. My lord, it can be taken up any other day, my lord, rather than today, my lord.
This is how, don't complain. This is how cases are not being heard. On the prayer of learned counsel for the petitioner, matter stands adjourned and be listed after 2 weeks.
Oblige, lordship.
May I pray for a date?
Give a date.
Interim is there, Lordship.
We are not extending the interim. List this matter on 22nd.
Lordship.
I beg to mention item number 8, Lordship.
Item number,
8, Lordship. Due to some personal difficulty, Lordship, English Council is not able to come, Lordship.
what is the issue?
Lordship, allotment of flat in Assam housing complex. Lordship.
Yes, who is for the housing board? What is your instruction?
Lordship, it's a minor daughter is suffering from critical disease.
Uh,
Still, he is in treatment in New Delhi.
Uh.
We are ready to provide a housing board flat to her.
No, this is not the issue. Other issue is where is the discretionary quota of the chairman and what is the principle of discriminatory quota?
Yet to be fill up the requisite form, Lordship. We are
That we
requesting,
understand.
Lordship.
Housing boards, flatters for, there are some object of construction of this house, flats for renting it out, isn't it? Any Tom, Dick and Harry will not get. So there are some criteria. And at the same time, you have kept a percentage for the discretionary power of the chairman to allot. What is the basis of the discretionary power? Discretion cannot be unfettered. That is what instruction is required.
Lordship.
What? What lordship? Tell us.
Lordship, instruction is required as because of earlier, I was not in there, Lordship.
Have you not gone through the earlier orders?
Or yes, I gone through the earlier order.
So one of the
Lordship.
orders is this is, they will have to satisfy what is the discretionary power of the chairman and under what authority of law the discretion is given and what is the parameters of exercising such discretion. Learned counsel representing the housing board, Assam State Housing Board
Lordship.
submits that he will obtain the complete instruction in terms of discourse earlier orders, more particularly as regards the power of the discretionary power of the chairman to allot flats and the parameters of exercise of such discretion. Full stop. List this matter after 3 weeks.
Lordship. Lordship, our name should be reflected in the positive. as
Okay, a registry to
Standing
reflect the
council.
name of the Standing Council of Assam Housing,
Assam State House.
Assam State Housing Board.
May I please, your Lordship?
Yes,
My lord, with due consent of the other side, my lord, I beg to mention item number 2 of admission of today's list, my lord.
Hmm.
Only 10 days time.
okay.
If possible, my lord, on 18th of
Okay,
August, my lord.
on the prayer of Mr. Borthakur, learned counsel for the petitioner, list this matter on 19th of 28th of August
Yes,
for further hearing. Full stop. In terms of this court's order, earlier order dated, so it's your last order to Simon.
My lord, item 13, my lord,
Item,
13, I would like to adjourn this matter, my lord. Item
you
13.
want to adjourn this matter, adjourn it. Why are you asking this court? You want to adjourn it. Item number
13, 1, 3, my lord.
13.
We adjourn.
Mr. H.R. Chaudhary, learned counsel for the petitioner, press for and is granted 3 weeks time. To do what?
My lord, to take instruction from the client, my lord.
To-
What is the
To
present?
complete his instruction.
condition?
My lord.
Yes, Mr. Deva.
Lordship, I am submitting on behalf of S. Thakur, Lordship. So for the item number 11 is concerned, Lordship, probably this matter will be closed. Here, Lordship, the advertisement for appointment of Gambhira was assailed. That was in 2020.
That notes, the whole ground was that earlier Supreme Court judgment is not followed.
Yeah.
They have subsequently, in terms of the Supreme Court judgment, framed a regulation.
Close,
Full stop.
close.
Mr. A. Dekal appearing on behalf of Mr. S.
S. Thakur.
S. Borthakur, learned counsel for the petitioner submits that in view of publication of notification providing procedure for selection of Gamburas, this there is no cause of action for this writ petition. Accordingly, the present writ petition stands dismissed. Present writ petition stands
Close.
closed being infructuous. Interim order, if any, stands vacated. Yes,
Deployment.
you want to give that note?
Yes, my lord.
Yes, give it.
So, my lord, already you have prepared.
Huh? Okay, fine. We'll giving a Borthakur's already we have dictated the facts, your arguments. We'll just verify this.
Much obliged.
Only on at 19th we'll do the final thing. Whatever, just but you give that from the case diary and all, at least factual parts, so
Yes.
that,
Obliged.
yes.
Motion item number 1.
In respect of FIR dated 13/6/2014, your lordship.
Why are you apprehending?
I apprehended because of the fact, your lordship.
Then you have to recall the bail granted to your brother also. That
Brother is
gives,
granted
that,
bail, your
I think your order was, let us register a suo motu case for recall of his brother's bail, Mr. Das. Now it seems that both are involved.
Lordship, brother was granted bail without perusal of the case.
Yes, because your specific statement was that brother was not there at all at that period, and this was substantiated by records, you have granted bail. Now, where are you apprehending?
My apprehension is that, your lordship, neither I am a Mondal lordship, nor I am in any way connected with the lordship.
Case diary. No. We have serious doubt because allegation is something serious. If necessary, we'll have to recall the, if materials are found after case diary, we'll correct our mistake. No doubt about that.
My lord, page 15 may kindly be looked into. Notice was served on your lordship 19/7,
Uh,
but I have been directed to appear on 30/6/2024, your lordship. Page 15, your lordship.
No, we have seen that. Everything we have seen.
22nd of August.
This arrest is invited by the council, not by the accused. Yes. Next.
For being here.
Imam Gaur. Item number? None appears for a petitioner call list on 19th of
Case there is not received, my lord.
case diary case there is call for is not received. List this matter on 22nd of August 2024. Any interim order? No.
My lord, nothing is written.
No.
Perhaps not.
No. List accordingly for production of case diary.
23.
23, my lord, charge is submitted.
Any interim? No,
Interim, perhaps not there.
not. Charge sheet number?
All right, I'm giving the message.
You know, the principle we follow here. If it is interim, then it will continue till
Yes.
you appear, file considered. If no interim, then we'll say with a liberty to approach. We cannot change that.
My lord, if we approach there, they can consider, my lord, only one thing, my lord, with all humility I place,
Yes.
my lord, your lordship may just-
Problem is the courts are not run by humility. It's by
I
law.
understand, my lord. My only thing that, my lord, subject to all correction, my lord, the policy which says, my lord, FI says that, my lord,
No, we cannot go to all this. We are just giving you argue all this before the,
the liberty that we will approach the court and they will consider, my lord.
yes, as per law, that is the order.
My lord.
Case number 102.
Don't always argue on the basis of what is prompted by the junior.
My lord, but I will never.
Yes. Case number
2/24,
24,
dated 29/7/24.
29/7/20.
All of this message will form part of the.
Yes, the message sent to Mr. Das as regards filing of charge sheet is kept on record and marked as document X. Of course.
24. Orders.
Please.
This is also, where is Mr. Kyle? Same, these are, there was a stay order, so Dean is recovered like in Prox was. None appears for the petitioner on call, list after 6 weeks.
25.
None appears for the, yes. Yes, Mr. Ali.
Lordship, what happened in this case, this is a matter also against the judgment delivered by the district judge under the Assam Land Grabbing Prohibition Act.
Okay.
So land grabbing prohibition, Act, they have been found, your lordship, that
Why
without-
this matter is listed for
they are the
orders?
grabbers.
Who will file reply affidavit?
Lordship reply.
Matter is ready, pleadings are complete.
6 lakhs, the die, 226 is a public law remedy, your lordship.
Huh.
Now it is a dispute between two parties.
Uh,
So they can't invoke this 226. That is the.
so your case is that the case was under land grabbing.
Let's-
He filed it.
No, no, I
You-
filed.
You filed it.
I
Then what
filed
was
that-
the order?
It is found that actually he is guilty of grabbing land, your lordship, without title. He has actually grabbed the other's land.
Mm.
It is a club, you're under the.
So it will be under 227.
220.
In view of the Suryadev Rai and subsequent modification in which case?
Not aware.
What is the judgment? That was clarified. Radheshyam. Radheshyam. So in terms of Radheshyam, it will be a 227.
But let there be order, your law, to that effect. And the matter may be fixed for final hearing, your lordship.
Will come for it to admission stage, this can be decided. What is your ground of the challenge to the order?
Lordship, our main evidences were not considered, my lord.
What is your evidence? That, okay, we are not passing any order.
We have also filed one.
So your,
IAM
if your lordship thinks that the.
That is because for
it
that
should
we'll
be
have to.
converted to 227, your lordship. I have no objection to that also. Because this matter on that point, your lordship.
What is your argument to his? Yes, Mr. Chaudhary. His argument is that after Suryadev Rai read with Radheshyam, 226 is not maintainable. So 227. So let it be converted under 227. What do you say on that? If you want to argue on that. If you want to argue on that, we'll fix it in the admission stage. Then question of maintainability will be kept open. On that day, we'll decide it. Hard. Learned counsel for the parties, Mr. S. Ali, learned counsel for the petitioner,
I am
referring
for the
to
respondent. your lordship.
respondent, referring to the judgment of Suryadev Rai 2003 3 SCC. I forgot the citation. And no, Suryadev is 2003 3 immediately after amendment. And this, because that was the issue at that point of time, what will happen 115 and all. And subsequently Radheshyam Agarwal, na? Or Tiwari? Because no civil lawyer is present here. Yes, Samnur Ali.
Lordship, I forgot the reference, your
Okay,
lordship.
Radheshyam submits that this writ petition under Article 226 is not maintainable. Mr. Chaudhary submits that he will address this court on the next date in as much as pleadings are complete and matter may be listed in the admission column. Full stop. List this matter on.
Lordship,
Keep that consensus.
last week of this month, your lordship. That may be fixed, your lordship.
List this matter on 30th of August 2024 in the admission column. In the admission column. The maintainability of this application under Article
No, no,
226.
This is not a question of mental, 226, it is a private dispute, cannot be, your lordship.
If it is
under
not
article-
maintainability, then let tell us
That-
what
that-
should
so
what should
today
take on-
itself, I have no objection, your lordship, today itself it can.
No,
be-
no, we are saying it is an question of maintainability of an application under Article 226 is be decided on the next date fix. If we decide not, then we'll ask for conversion.
So your
List
lordship-
accordingly. On that day, we decide that. Yes, next case.
So till today, your lordship, there are as many as 15 decisions on this point, your lordship, all are under Article 227. And he should know,
Huh?
and he should know, your lordship, that
He wants that he will address on that.
all the decisions, your lordship, which has been rendered, so all are under Article
So
2.
therefore, we are keeping it at admission stage. Okay, if you want,
Sir,
we are
one-
fixing on,
one is-
we are fixing on next date on admission stage, then thereafter, if we convert it, we'll do it on the next 30th. List this matter on next week is on 8.
On your lordship.
8. Next week, 8
হালকা দিয়ে গরম দিতে পারবো।
in the admission column.
26.
Here, my lord,
This is hearing matter, na?
small point, my lord,
No, Mr. Das was to.
Actually, on last occasion, your
Ah.
lordship wanted to dispose it of,
Ah.
my learned friend is pressing for bail.
Hmm.
No, Janu.
Ah.
But matter is solved, my lord.
I'll take only 5 days, 5 minutes
I
maximum.
understand your 5 minutes, an hour,
Yes,
5 hours.
yes, that's why, my lord, I pray for the bail, my lord.
Bail, I'm finding it difficult, Mr. Das. See, I'll have to give a conclusion
Yes, my lord.
that this is this, therefore this is a small quantity.
No, my lord.
That will be a final determination so far relating to the entire matter.
No, my lord. Here, my lord, my lord, as so far as the NDPS Act is concerned, my lord, it is a strict act, my lord. Stringent, my lord. Everything has to be followed, my lord. If the prosecution or the, my lord, the IO, my lord, they do not follow each and every thing in the NDPS Act, my lord, it goes. my lord.
Understand?
Yes, my lord.
These are the matter of you have been convicted by a competent court. Parameters of bail will be in a different context. In a case of more particularly NDPS.
Yes, my lord.
We cannot go details to the niceties. In the face of it, it should be that this is a case of acquittal.
Yes.
That according to this court is we are not finding. I can pass an order today itself rejecting your bail, fixing this matter for hearing.
Yes.
If you want that, I can do that right now.
No, my lord. Prima facie, my lord.
I am not satisfied.
Yes, my lord. Prima
Because you have
facie-
argued 3 days, I am not satisfied.
No, no, my lord. Prima facie only one point, my lord. That point I also did not raised earlier also, my lord. Now subsequently I came.
And another aspect is that there is a judicial order saying that bail application should be taken up along with the appeal. And your IA is for early hearing.
No, my lord, one point.
No,
My
no,
lord,
point to point will come to that.
My lord, may
See,
I?
we want a judicial discipline. First thing is that, in fact, we heard on interim prayer because after going through the record, since you were insisting, I applied my mind.
Yes.
Then I saw that initial IA in fact was rejected. Is not it? Saying that no, we are not entertaining it, let appeal be heard. Okay. Therefore, you file an application saying that please hear my appeal. So therefore, no question of consideration of bail.
There's a fault on my part, my lord. Only one point, my lord. I did not raise, my lord. Here, my lord, what happened, my lord? So the two certificate, my lord, the inventory and certified by the magistrate is not there, my lord. That point, just I'm pointing out.
So that this is a
That was not raised, my lord.
matter of hearing.
Yes, my lord.
So you have concluded almost, you have concluded all your part.
Only that point, my lord.
Only that point.
That point.
That it should be, and on that ground, you rely on the recent division bench
Yes,
judgment.
my- yes.
That we understand. That part is there.
Yes, that-
There should be separate certificates.
Yes,
No, one will not do.
Yes.
This is the case, and Mr. Bora's case is also same.
Same, my-
And Mr. Das on last occasion said he will argue. Now, do you want to add something? Or we can keep it as CAV today?
My lord, my friend may not be aware,
If
my
you
lord.
want to, if you want to argue something further, then we'll have to, we have no option but 2 options. One is releasing it from part heard, fixing it before any other court for hearing. Or next is that on 19th or 20th or that week, we'll fix this matter and dictate this order. After hearing it. These 2 options.
So far, my lord, the
My
question
lord,
of
my
certificate.
learned friend may not be aware, my lord, because this point, my lord, I have not raised. That two certificates are required, my lord, that.
Anyway, my lord,
He may
that
argue on
that is
that.
a matter of record.
Hmm.
Certificate, I cannot improve. If certificate is
Yes.
not there at all, my lord, I cannot improve.
No,
Yes.
here whole case is that forget about others. First, one part of the matter is that quantity, what should be, and whether the tablet comes under narcotics or drugs act. This is one issue. They are relying on a judgment of the Allahabad High Court.
That part I
Okay, so
not
that part.
not they are not. I'm not arguing.
So he is not arguing. Only grant is violation of section 52.
52 and moreover, my lord, I have been
52 and the primary evidence so far relating to the certification, where according to him and in other case, Mr. Bora is arguing, where it has said that certification should be 3 different certificates, not one. And in his case, that was not done. Therefore, on this count alone, he is liable to be acquitted. And on that ground, they are relying on a decision of a division coordinated by division-based recent judgment, which elaborately dealt and what will be the effect of that. So,
and moreover, my lord, I have been convicted under 22C
see,
and I ought to have been, my lord, charged under 21C.
21.
20.
Oh.
Can deal with. I have examined the law on that point. But regarding that certification, my lord, but let it come up on next Tuesday or Thursday, my lord. I will examine.
Next
the record.
Tuesday, Thursday is difficulty. That is what I am saying.
Sorry, my lord.
That's why I'm saying 2 options. One is fixing it on the week commencing from 19th of August.
For my
Or if
satisfaction, once
Mr. Datta says, no, I cannot wait, these 2 weeks are in between, I'll release it
I
from.
have completed my argument, lordship.
No, you have completed. But there are some technical difficulties.
Yes,
This is the problem.
yes, madam.
Release this matter for further hearing on 19th.
My lord, from 15 to 22, I will be not there, my lord.
15 to
22, my lord. Can it be on 27, my lord?
15, 16, 17. These are the, what are this matter?
19, 20, 21, I will be not there, my lord. That week, my lord.
Oh, 19, 20, 21 will not be there.
Not actually.
Vaishno Devi.
27.
28 তারিখ?
Vaishno Devi.
No, no, man, not Vaishnavi.
Then 19, 20, 21. Okay, will not be there because 23rd is a holiday.
Yes, man.
So it will be on 28.
Yes.
That's 20. Just verify give the judgment to.
Yes, I'm giving, man, right now, man. Paragraph 32 to 42.
Yeah, if it is 27, my lord, it will be Tuesday, my lord. Perhaps hearing day will be better.
27.
Well.
27.
I'm on right now.
Obviously.
Yes. Yes, Mr. Chaudhary.
Lordship, in this case, before my learned friend starts, Lordship, I have been told that copy is not served upon us, that amended writ petition.
Will serve my letter if we.
Okay.
And
So when we can, what is the issue here?
there are some subsequent events, my lord, after the.
Okay, you have amended.
We have amended and an amended writ petition has been filed.
That IA was filed for
Okay,
amendment. That
Mr.
was,
H. Sharma, Learned Council, State Council
Well,
submits that
There are newly implemented respondents, my lord, the notice.
Mr. Datta,
No, my lord, from 32 to 45, my lord, the new executive.
they
committee.
have not filed affidavit.
No,
No, notice,
newly implemented.
My lord, the notice should go to them, my lord.
notice gone or issued or not?
Not issued, my lord.
Notice
This is
not.
First time, my lord, after amendment. From respond number 32 to 45.
Heard Mr. D. Chaudhary, Learned Council for the petition. Assailing an order dated 22/7/2023 issued by the respondent number 2, dissolving the management committee of Sri Sri Harimandir Nalbari. The present petition has been filed. Full stop. Subsequent to filing of this writ petition, there were, according to the petitioner, there were certain developments. Accordingly, writ petition was amended. Writ petition amended with the permission of this court. Full stop. Mr. Permitted from this court. Some new respondents also included
32 to 45. my lord.
in terms of this court's order dated
27/6/2024.
27/6/2024. 2024. Full stop. No notice has yet been issued to the aforesaid respondents. Accordingly, let a notice be issued to respondent number
32 to 45.
34 to 45.
32.
32 to
45.
45. 32 to 45. Returnable on. Give a date. After 4 weeks, give a date. Are you appearing? You are appearing for those respondents?
2 and 3.
Oh, no, 2 and 3.
3 and 4.
Already they are in party, already they
No,
are.
you are the party. That is not. We are
No,
want to.
One
no,
I is there, Lordship.
Huh?
I.
No, we'll come to that. Just let us complete this.
Yes.
Returnable on 5th of September 2024. Before the next graph,
The service will be both the registered
First
post and dusty
steps be taken both ways by registered post as well as usual process. Full stop. The petitioner is also permitted to effect service through dusty. However, same should be routed through this registry of this court
Okay.
and affidavit in this regard in proof of service be filed thereafter. Full stop. At this says Mr. Das Learned, Mr. Sharma, Learned Counsel representing the state,
1 and 2.
was the state respondent, that is 1 and 2, submits that amended copy of the petition has not been served upon them. Full stop. Responding to such a submission, Mr. Chaudhary assures that such copy be served within the course of the day in the office of the Learned Senior Government Advocate
By Monday,
by Monday before in the office of the Learned Senior Government Advocate. Full stop. Please this matter accordingly. In the meantime, parties may exchange their pleadings. Okay, উপরে লিখে দিবা, this the amended writ petition be served upon not only all the respondents, if not served already, by Monday next. What is this IA?
I, Lordship, I have prayed for striking off.
Why? Who are you?
I am respondent number 3.
Okay, the IA likhiwa. The present application is filed by respondent number 3 for striking his name from the area of parties. Mr. D. Chaudhary, Learned Counsel for the petitioner, submits that the respondent number 3 is necessary party. Therefore, he would like to file an objection in the present IA. Prayer is allowed. List along with WPC 5013/2023 on September 5th. I did. Yes, Mr. Sahala.
Contribution notice was issued, my lord, according my lord.
My lord, the writ petition was allowed, we are issuing the first tender, my lord.
Writ petition was allowed by what, sir? So show us, what is the order? Page 52.
No, my lord. Writ petition, the final disposal of the matter.
No, order which you allege that has been violated.
My lord, yes. That is annexer, my lord, annexer 4, my lord, page 27.
Page 27.
Page 27, my lord. Operative part, my lord, page 29.
Page 27.
Operative part, my lord, page
20.
9, para C, my lord. Para 6.
Okay, now what happened?
What happened, my lord? On.
So it was directed till, it is interim order or what? What is the main writ petition?
Yes, my lord, writ petition.
So this matter was disposed of or what?
Yes,
The
ma'am.
pending.
Dispose of, my lord.
Finally disposed of with what?
Allowing a,
Then,
my lord, we are issuing the first tender.
My lord, not my lord, not issued till today, my lord. My lord, direction was given, my lord, to issue my lord, first tender.
okay,
But what happened, the contempt petition, my lord, the issue is, my lord, the interim order was passed, stay order passed by the honorable court on, my lord, 4/10/2023. Well, same day, my lord, the respondent authority
okay,
issued the
Mr.
order.
Saji and Sahala, Learned Senior Counsel appearing for the respondent, prays for and is granted 4 weeks time to file an affidavit. list accordingly. Since you are disputing, let them respond. Bian Chawla, Senior Counsel, assisted by N.A. Singh. Yes, 20.
Lordship, hearing this case.
My lord, your lordships, my lord, may see the order, my lord, dated 26/4/24. You are directed to, my lord, produce a photocopy of the register, my lord.
Lordship, we will submit all these things through an affidavit, Lordship. And
When?
the Lordship, after 2 weeks, Lordship, any date, Lordship, I will submit all this.
Okay, 24, Mr. Sahala giving a time. Yes. Mr. Goswami, learned counsel for the respondent. No, Mr. G.N. Sahiwala, learned senior counsel assisted by Mr. A.K. Sahiwala, submits that the pursuant to this court's order dated 26/4/2024, the respondent Sorupothar Municipal Board was to produce photocopy of the register of what? Photocopy of a register
Register, my lord.
with effect from 1/3/2023 to 31/3/2023.
Then 31/5/24, my lord, they paid for time to file the register.
Thereafter, on 31/5/2024, Mr. J.K. Goswami, learned a government advocate, sought for time which was granted. Full stop. Today, Mr. J.K. Goswami submits that he has received the instruction and would like to file the affidavit within a period of 7 days from today.
Lordship, 2 weeks.
It was 31/5. Within the period of 10 days. Full stop. Prayer is allowed. Let such affidavit be filed on or before 10 days, Mr. Sahiwala.
It will be, my lord.
On or before 22nd of
12th,
on or before we are giving them 14th of August. On or before 14th of August, and therefore list this matter on 21st of August 2023.
Much.
Yes, count.
This application is for substitution of the legal heirs, my lord. I have.
Who is
paying
for the respondents?
It's all
State.
state parts.
Mr. Count, the present application is filed by the applicant who is writ petitioner, isn't it?
Yes,
In-
this passed away, then the
File an application for substitution of the name of the deceased writ petitioner in WPC 2274 of 2022. It is claimed that the petitioners are the
applicants are the wife and
applicants are legal heirs of only applicants or applicants.
applicants, wife and the son.
Applicants are legal heirs of the deceased writ petitioner in WPC 5 WPC number 2274 of 2020. Full stop. Peruse the prayer made in the writ petition. What is the prayer?
Prayer for substitution and making.
No, prayer in the writ petition.
Prayer in the writ petition, my lord, is for cancelling the impugned order, my lord, passed.
What is the impugned order? Any cause of action survives?
But there is one.
What was the action challenge in the writ petition?
31/10/2018, my lord, as a report, my lord.
What was done by that order?
By that order, my lord, they had said that we had prayed, my lord, that our name may be shown, my lord, as regards the land which was taken over by the railways. The railways have themselves stated, my lord.
Okay, peruse the prayer made in the writ petition. Full stop. In the considered opinion of this court, right to sue survives upon the applicants on the date of the deceased writ petitioner. Accordingly, the full stop. MS B. Bormon Learned State Council has not objected to such prayer. Full stop. Considering the matter in entirety, the present application stands allowed. The applicants be applicants or applicant? Applicant for as to applicant be substituted as writ petitioner in WPC 2274 of 2020 in place of deceased writ petitioner, namely Anil Kumar Das. I extend this disposal. What about 32? Okay, it is hearing. Okay.
Wait, with your lordship.
Yes.
Lordship, the matter is still subsisting, and I have already taken steps, your lordship, on respondent number 2.
Matter is still subsisting means still whether any cause of action survives.
Sure.
What is the issue here?
Your lordship, a recovery proceeding was initiated, your lordship, against the petitioner for non giving the loan amount, your lord. There was some default, your lordship. Ultimately, recovery proceeding initiated. He gave a proposal for one-time settlement.
No, that is not the issue. Issue is, suppose a notice is issued. A Bakizai certificate is issued and a notice is issued to you to pay. Isn't it? What is the procedure to be followed thereafter?
In this case, your lordship, already a proceeding was initiated under the
BPDR, Bangalore Public Demand Recovery Act.
lordship.
Isn't it?
Sure.
What is the procedure prescribed under Bengal Public Demand Recovery Act? As far as our limited knowledge goes, whatever you have raised in this petition can be considered by the Bakizai officer because you have a chance to file an objection saying that this is the situation. If that order is rejected, then the appellate authority is Assam Board of Revenue.
Now, the
Then
proceeding-
Board of Revenue can decide and thereafter you cannot be remedialess. You can come here.
In this case, the
No,
proceeding,
tell us the legal provision. For facts, forget.
a proceeding was initiated under the Recovery of Debts due to Banks and Financial Institutions Act, 1993.
What is the remedy therein?
In that case, what happened, your lordship, already attachment order has also been issued. Immediately I approached the bank. There is a guideline of
What
the
is the remedy against attachment under this act? That was that bank debt due to bank act. So therefore there must be an way.
No, that is the, I am not agreed with that. What I am agreed with your lordship, after this thing, your lordship, there is a bank guidelines for one-time settlement. So they were saying that I was supposed to pay rupees 17 lakhs. I immediately approached them by filing a representation that I want a one-time settlement. I'll pay rupees.
Who are you, mister?
Lordship, actually things that they have to take in face step because our name is showing there in Okalat cause list. That's why I am appearing. Our name may be stuck down because we already returned the file to the bank.
Okay. You are for which bank?
United Bank, Lordship.
You are Mr.
MM Zaman. On
M?
behalf of MM Zaman, on behalf of S. Samaria, Lordship.
Mr. M.M. Zaman, appearing on behalf of S. Samaria, submits that they are no more holding the brief of
Bank.
Which bank?
United Bank.
United Bank of India, and United Bank of India having a new set of lawyer, and accordingly they had already returned back the files to the bank. Full stop. In the opposite backdrop, the learned counsel for the petitioner submits that he may be permitted to take fresh steps upon respondent number 1. Prayer is allowed. The such steps be taken within a period of 5 days. If it comes before this court, you will have to satisfy all this. It's not that you will come and file a writ petition like this. Within 5 days by both ways. List after 6 weeks.
Interim order.
Interim order pass earlier shall continue till the listing till the next date.
Obliged.
Till the next date fixed.
May I please, your lordship?
Yes.
Lordship, the matter is, lordship, without initiating land acquisition process, lordship, the authority have marked our land to construct a road cum dike, lordship.
Yes, what is your instruction?
Patta land, my lord, as
Huh?
well. It is a Patta land information has been.
The fact is admitted, lordship, through an affidavit filed by the lordship district commissioner, lordship.
Yes, where is irrigation?
I have to call them.
Huh?
To call them. Name is already.
None appears for the
Water resource, no,
Huh?
sorry, water resource.
Water Resource Department. Hard, no way out. We'll stop the dike whatsoever. this is not the responsibility of hard. The learned counsel for the petitioner also heard Mr. Borman, MS Borman, learned state counsel, full stop. Direction was issued to the Learning Standing Council of Water Resource Department as well as to Ms. MS Borman to obtain instruction whether the house of the petitioner is standing in a patta land and whether in course of construction said house is to be demolished and whether any land of the petitioner has been used in the construction of the dike. Now, what is your answer? Though,
These are-
huh?
Many pattas are there, my lord. All these
Though
pattas-
an instruction has been received.
Lands are patta land, my lord, and last page is the beneficiary list according to serial number which they have made the estimates, made the estimates, my lord.
Full stop. Pursuant to that, the additional district commissioner cum CEO DDMA Hailakandi. DDMA Hailakandi has furnished the instruction to MS Burman, learned junior government advocate by its communication dated 1st of August 2024, which discloses that Ratanpur Part 2 and Bahadurpur Part 2 falls under periodic patta land and the petitioner's name has been included in the Jirat compensation beneficiary list as per assessment report of the concerned ASO. Full stop. The communication of the circle officer on the basis of which such facts was communicated to MS Borman reflects that the land in question are patta land and at this stage possession of the petitioners without conducting field verification are not possible as LR assistants are engaged in time-bound government project, that is verification of digitized settlement maps. Full stop.
Beneficiary list one, list is 32 pages, my lord.
List of beneficiary of Jirat is also annexed with the said documents.
Yes.
What is the name of the petitioner?
It is
No, sir.
1 to 23 is, they have shortlisted is, my lord. Beneficiary numbers are there in the last fourth column, my lord, because it's a huge compilation, so they make it short.
These are the petitioners.
Yes.
At least the name of the petitioners also finds in the list forwarded to MS Burman, which discloses that
Serial numbers are there, my lord. at the
which
page.
discloses that have you got Jirat compensation? List of person that the petitioners find place in for Jirat compensation and details also shows that those lands are having houses. Jirats are paid for houses and all. However, from the aforesaid position, it is clear that no land acquisition process has been initiated. Such fact has also been ascertained by MS.
Annexure C to the petition, my lord, that Jirat proposal has already submitted to the department, my lord. That
No,
we-
Jirat proposal has already been submitted to the department.
that
However,
communication
such payment
is-
has also not been made.
Yes,
Uh,
that is the reason we are.
It is true that a public project should not be stalled for protection of the right of citizens. For protection of right of citizens. However, in the present case, yes, mister, we are staying this project. What no?
Timing. Mr. RM Das.
Forget about RMDAS, we cannot wait is.
Timing, Lordship.
It is correct to say that you are not monarchs. We understand development works, but can you do like this?
Timing, Lordship. Is in port number 1, Lordship.
Patta land, you will only give Zirat low land acquisition compensation, and the Zirat has also not been given. You are going to demolish the houses. What is the public purpose? Public purpose is to save people from flood. Okay, this is worse than flood. Without flood, they will be. Yes, Mr. Das.
They are in Patta land.
They are in Patta land. You have not acquired the land.
Lordship,
You have only compensated Ziras under what law? Tell us.
Lordship, we are not acquiring the land. Acquisition is done from the district authorities. Lordship. We place our demand to the district authorities accordingly. District authority used to.
Are you aware of the provision of Land Acquisition Act?
Lordship.
If you are aware, let us remind ourselves. Land is acquired by the collector
Yes, Lordship.
on the request of the
Requisition.
acquiring department. You are the acquiring department. Had you made any request to the authority?
Yes, Lordship.
If you have made, is there any land acquisition process? No,
Regarding that, I am not.
no,
aware.
no, they have said no. So
Para
if
five,
no,
we have-
can you take over land of the people?
Lordship, land availability certificate we have received from the circle officer. Lordship.
We understand.
Lordship.
There is land is available.
Lordship.
Where is your house, your residence is situated? Guwahati, which place?
Continue.
Gandhi Basti. The Dispur, somebody says that this building is required for an emergent necessity of construction of a data center.
Lordship.
The circle officer said this land building is available. So let that be demolished without any acquisition and fix some Zirat. It will be given whenever it is required. And till then, Mr. Das will be on the street or in a rented house. Is it what you propose to say?
No, no.
If no, then after half an hour, what is your proposal? How will you compensate them? When the land acquisition process will be start? Otherwise, you are staying this project. As simple as that.
Because upper stream.
We are guided by rule of law. A person shall not be deprived of his right without due process of law. The due process of law to deprive a person from his right of land is a Land Acquisition Act. And there may be emergency necessary where even without notice you can take over. But you will have to say that this is the emergent necessary. Then you will have to pay in advance them the money. So according to us, this is not due process of law, so we'll stall this. We'll stall this. Come back, have your instruction. How you are proposing after half an hour. At 1. 12:45. Yes.
Here, my lord, I have already made my submissions, my lord.
Hmm.
It's regarding, my lord, the withdrawal by the prosecution, my lord. And so far, my lord, my lordship.
I might have to adjourn. Yes, what is your instruction?
My lord, the last occasion, my lord, what I promised before this court,
Mm.
I'll comply with. I'll talk to the governments,
Mm.
and we have taken the decisions, my lord. My lord, of the record, our internal communication I'll place before your lordship. We have already proposed has been given to the government to change that line, my lord. এখন দি দিবচোন বাইদেউ। Along with the Home Secretary, Secretary of Home, Advocate Generals, and the LR, all are present. And it's placed before the next committee.
Okay, on the prayer of Mr. Fukan, Learned Counsel, Public Prosecutor, matter stands adjourned in as much as it is his submission that pursuant to deliberation made in this court, the state is proposing to amend certain provision of the SOP so as to be with conformity with the provisions of the criminal procedure code in as much as new law, that is BNSS.
Sure.
Full stop. In view of the aforesaid, matter stands adjourned and be listed on 1st of September.
My lord, yes. Within this month, we have completed.
1st of September 2024. But another aspect,
My lord.
what will happen to those which has already been file.
My lord, yes.
That is also whether it will have a retrospective
My lord, yes.
amendment
Yes.
or it will have a
That part also will take care
prospect.
of.
You will
it,
have
my
to
lord.
take note of. We are not disclosing this, that your internal communication.
Well, 1st September, second,
2nd September.
and my lord, interim order passed away.
Interim order passed.
My lord, a copy of the ordinance.
Till then. A copy of the Mr. Fukan is permitted to forward a copy of this order, a downloaded copy of this order to the concerned authorities.
Much obliged.
Lordship, this matter notice was issued earlier.
Hmm.
They have not yet filed any response in this matter.
Okay, who will appear?
Time for response number 3.
This is a matter of 2020.
Lordship, there is an industrial scheme under which we have set up our industry
Uh,
and subsequently they rejected our application.
Let them respond. You are for,
Response number 3, Lordship.
uh,
Pro forma response.
who is Industries and Commerce is the main party, 1 and 2?
1 and 2.
Mr. Todi?
Lordship.
Yes, who is 1 and 2?
Union of India. In fact, respondent number 3 is also concerned
Who
department.
is respondent number 3?
Industries Department. State
Yeah,
of Assam.
okay.
Industries
The learned counsel for the respondents number 1, 2 and 3 press for and is granted 3 weeks time to file affidavit. List this matter on
1, 2.
uh, 2nd of September.
Much obliged.
My lord, item number 7, last time I got information one affidavit is ready to file, my lord, from the forest department, my lord. They have already signed the copy, my lord. I have the soft copy only now.
Okay, MSA Gayan learned. Nothing survives in this petition.
As per this affidavit, my lord, some development is there regarding the.
We
care and-
understand there is a policy. What
Yes.
development? We know that policy. They have brought a policy by which Union of India wants that this resource should slowly go out of for use.
Yes,
So coal will slowly go out. They will shift to nuclear energy and electrical. Of course, that will give that will create some problem to these laborers. They might have taken some policy decision in this regard, but as such, in this case, no, nothing.
court may discuss.
MS Gayan, Learned Counsel for the Respondent Union of India. Press for and is granted 6 weeks time to file affidavit in opposition. List accordingly.
Most obliged.
Let us see. This petition is not filed by the laborers,
It is,
is not it? This is filed by the owners of the laborers, the employer, is that it, Mr. Counsel?
Oh, Lordship, this is Purvatkar Khazan Mazdoor Sangh, Lordship.
We understand this is a Mazdoor Sangh. Yes. Yes, Mr.
Matter has
Gupta.
become infectious, my lord. Now there is a family settlement between the parties and they have got their
Okay,
licenses renewed.
okay. Mr. Gupta, Learned Counsel for the petitioner submits that in view of subsequent developments, this matter has become infructuous. Accordingly, writ petition stands dismissed. And MS R Deca,
for
Learn-
reference number 4.
Learned Respondent number 4, also submits in the same line, full stop. Accordingly, this writ petition says closed, being infructuous.
My lord. Obliged.
May I please, your Lordship?
Yes.
The petitioner has received the due amount from the respondent authority. The matter may be, the matter has turned infectious, so matter may be dismissed.
Learned counsel for the petitioner. Payment made.
Yes.
Learned standing counsel for
PNRD department.
PNRD department submits that this petitioner should not have any grievance as the payment of bill claimed by the petitioner has already been dispersed. Full stop. The learned counsel for the petitioner submits that his client has received this bill and therefore nothing survives to be adjudicated in the present writ petition. Accordingly, the writ petition stands closed, being infructuous. Much.
Yeah, please. Anuj.
Yes. What is this?
They got 50% of the compensation, rest 50% they are claiming. Our claim is that we have paid 50%, rate 50% we cannot pay as because there is a dispute between the legal heirs.
So matter is referred to.
Not yet referred lordship, it's before your lordship.
Lordship, before that I am coming. Initially, my lord, we have no objection regarding the amount of the compensation. We have come to know from an RTI that, my lord, the compensation has been given in the name of 6 of our family members. So we have raised no objection. Accordingly, my lord, the field verification was done. That report is.
So basically, in a legal language,
Well,
and in a legal parlance, it is a dispute as regards apportionment. You are saying many things. According to us, this is a dispute as regards apportionment, though there is no dispute as regards quantum.
Lordship. Well, that has been amicably settled. There is a report from the circle officer, from the Lat Mandal to the circle officer. Then that report has been forwarded by the circle officer to the ADC. And thereafter, after that, my lord, 50% has been released to them and 50% should be released to us. On that basis of that, my lord, amicable settlement. That is on record, my lord. And after that,
So
after
therefore,
releasing,
your case is that it is not even case of apportionment because there is no dispute at such apportionment. We have amicably settled.
Settlement.
Now Deputy Commissioner into act upon that. That's all.
my lord,
Where is the
and
private
that
respondent?
amicable
Where is the private respondent?
My lord,
To ascertain that, yes, this is our settlement. We'll pass this order right now.
they have not entered into experience.
Have you served notice?
Lordship.
Where is that? Where is that service of notice? The basic grievance of the petitioner is that land belonging to the petitioner, petitioner's family was acquired and accordingly quantum was determined. Though there was no dispute as regards quantum, though no dispute has been raised as regards quantum in the present petition, however, a dispute arose between the family members as regards apportionment of such compensation determined by the competent authority. According to the petitioner, such dispute was amicably settled between the petitioner and respondent numbers.
Respondent numbers. 4 to 10.
Respondent numbers, petitioners and respondent number 4 to 10. And a settlement arrived at that the petitioner will get 50% of the total amount of the compensation determined and the rest 50% shall be given to the respondent number 4 to
10.
Is it correct?
Yes.
Lordship.
No, our part we have not received. That is.
So this was the settlement.
Settlement.
This was the settlement.
Was that 50% amount will be divided equally between the
That
two
is
parties.
50% means equal,
Equal.
equally divided.
Equally divided.
It is the grievance of the petitioner. I am recording his case only. It is the grievance of the petitioner that though acting on the basis of such settlement, the collector has disbursed the 50% of the total compensation to the respondent numbers
10.
4 to 10. However, the remaining 50% has not been disclosed, released to the petitioner, and therefore the present writ petition. Full stop. Office note dated. Full stop. To determine this writ petition, on the aforesaid statements, the stand of the respondent number 4 to 10 is necessary. Full stop. Though notice was, office note dated 4/2/2021 reflects that service upon respondent number 4 to 10 has been presumed on the, for the reason that the ID card has not been returned. Full stop. In the factual backdrop of this court, in the considered opinion of this court should not pass an order on the basis of such nature of service. Accordingly, the petitioner is permitted to take fresh steps upon the said respondents by both ways. The petitioner is also permitted to take service through the ST to be routed through the registry of this court, and thereafter the petitioner to file an affidavit. Full stop. If none appears for the respondents on the next date fixed and service is complete, this court may proceed on this petition on the materials available on record. Full stop. List this matter on after 6 weeks give a date.
They are staying together, my lord, no?
That's why.
That's interesting.
I think this is the best way, Mr. Sharma.
Lordship.
Otherwise, no. There might be some complaint after receiving that, don't give. That's why.
May I please, your lordship? Lordship, kindly, well, there is a fix for instruction, my lord. I'd like to draw your lordship kind attention, my lord, the first order, 11 October 23. Then I'll take your lordship on 7/6/24 order, my lord.
What is your case? Tell us first.
My case, my lord, we were legally, 3 legal learns, my lord, and the present petitioners as well as private respondent number 5, my lord. And thereafter, my lord, we have been heard, my lord, by the authorities, my lord, and we are under bona fide impression that they will apportion all the share equally to us. Suddenly, my lord, the authorities had released all the amount to the respondent number 5, my lord. Then we approached before this honorable court, and this honorable court had directed again to the authorities to hear all the legal years and you finding. Ultimately, they heard up.
Where is
and,
that order?
Lordship, in my writ petition, lordship will find, my lord, at page 23, my lord.
Yes.
24 is the order, my lord.
Yes.
May I read, my
Then?
lord?
No, not necessary. Tell us.
Then, my lord, then, my lord, page 26, annex R4.
Short lordship. There was a status report was short.
Yes.
This is the, if your lordship goes by that, the whole case will be.
Pursuant to this court's order dated earlier order, Mr. Sharma, learned counsel submits that he has received a status report as regards the claim and counter claim of land acquisition compensation by the petitioner vis-a-vis respondent numbers
5.
Respondent vis-a-vis respondent number 5. Full stop. In the considered opinion of this court, such status report be brought on record by an affidavit so that the learned, so that the petitioner can also respond to such status report. Accordingly, list this matter after 4 weeks. In the meantime, affidavit may be filed.
Lordship.
I think that let him have a son.
Lordship. That Bakijai proceeding was initiated, but the recovery that is. Lordship, I will.
Let him have
Lord-
this. Because now it will be between the court and the government. So
Lord.
let him have what is your findings.
Hello.
Yes, Mr. Das,
Yes.
your presence itself shows that this is a disputed amount.
No. My present will show that it is not disputed, so it's no facts. I'll tell how it
Very
is.
urgency.
Yes, there is urgency. Why it is not disputed, I'll tell from their own documents also it is not disputed. If it is disputed,
Next week.
If it is disputed, my lord, then it is the end of the matter. I cannot come up by way of a two
Yeah,
twenty-six.
that's correct.
But it is their own affidavit, their own calculation. I have received the amount. And today they are saying that for Van Causeway, there is no approval. If there is no approval, then why you paid 1 crore 10 lakhs?
Okay, we'll take it up next week. This matter we need some deliberation. It is not that they are exceeding, they will object to this, will to pass a delivery judgment.
No, that's true, my lord.
But that will not be
One-
possible sitting today.
And today.
And I'm not here
No,
from the
no,
next
I'm
week.
not troubling today. There is an order passed by this court. You produce a record to show
Mm.
that particular Van Causeway was not approved and it was cancelled.
Mm.
Till today, they have not produced.
They will the
Even,
next day.
even, my lord, even they produce that particular, that will be nullity of any order taken, passed by them. Because on the face of it, there is a calculation which has been.
So
declared.
therefore, this requires some deliberation. I think
It's your
so.
look.
See,
No,
Mr.
no,
Das, I'm not
Only
here
by
for
next
the
week, I will
next.
be difficult for next week for me also.
uh.
Thereafter, commencing
So
after
our
next week.
destination may be the same.
Yes, maybe. So that may be difficult.
So that's why it will not be
Maybe
possible.
after 13, my lord, after.
After 13,
14 of.
okay. As agreed to by the learned council for the parties, release this letter on 16th. 16th of August.
See, from 2012, bill prepared by them is admitted by known document not been paid. That's the position of the contract.
Okay, we'll see.
Deeply.
My lord, in these two cases, my lord, I am appealing for the petitioner, my lord. I am praying 2 weeks time for updated instruction. my lord.
Learned counsel for the petitioner prays for and is granted 3 weeks time to complete his instruction. List accordingly. None appears for the petitioner on call. You want to take them?
No, no, I'm for SNO 6 to 8.
No, that we understand, but name shows that you want to give them refuse. None appears for the petitioner on call list after 3 weeks. Yes, excise. Who is for excise?
Mr. Goswami and Goswami.
Where is N. Goswami? Call him. Wait for some time.
Yes, ma'am.
Your application is pending. Let them close it.
My application is pending only on the ground that there is a direction from the local MLA.
Ah.
There should not be any liquor shop in the Nalbari district.
That
But
cannot be a ground.
After that, my lord, they have issued, I have given an example where 3 shops have been sanctioned, my lord, after that.
Okay, we'll see. Is it there standing affidavit?
Yes, my lord.
Okay. If bring them. Timing means we'll finish the list, then we'll not come back. That it will next week. Yes.
I think it was 34 and 35 of supplementary list.
In
Yes,
this matter, my lord, I have to file affidavit. Just now I have served copy to the petitioner, my lord.
You have filed affidavit today.
Itself, my lord.
Okay.
Just now I have
okay,
received the copies.
MS Bormon, M. Bormon, learned counsel representing the state, submits that she has filed an affidavit today itself. Full stop.
During that also.
Learned counsel for the petitioner has already received such copy and she requires 10 days time, 2 weeks time to go through the same and to file reply if so advised. Full stop. Accordingly, list this matter after 2 weeks. Yes.
You may kindly fix it, otherwise.
Okay, give a date. After 2 weeks, give a date. After 3 weeks, give a date. Release this matter on 29th of August.
Of like. For the filing, go to the last page.
May I please, your lordship?
None?
No, lordship. Yesterday I have received one document. Lordship, I have raised 3 points, out of which in number 6, there is an agreement. I have sought for the agreement. They have earlier stated that they have not allotted the land, but now they are stating they have allotted but could not provide us the lease agreement, lordship.
Okay, since that is a issue to be,
Lordship, may I file an affidavit?
okay, it is submitted that the pursuant to this court's earlier order dated 29/7/2024 and 1/8/2024, some documents has been granted, but the petitioner is having still some grievances. Full stop. In that view of the matter, the petitioner seeks for 2 weeks' time to file an affidavit on the basis of the documents he has received. Full stop. Prayer is allowed. List this matter after 3 weeks. Yes, Mr. Gogoi.
Sir, we have filed our affidavit,
Okay.
not on record.
Okay.
Lordship, may kindly pass over for timing. My senior is under court number
No
7.
time for passover for timing.
Few minutes, Lordship.
No, few minutes we understand. What is the issue?
Regarding cancellation of registration under
Second year,
DST.
So in other cases, some orders
No,
will.
my lord, these are, my lord,
Okay.
2021 cancelled. He has approached
Okay.
to 24.
Okay, Mr. B. Gogoi, Understanding Council for Finance and Taxation submits that pursuant to this court's order dated earlier orders,
Yes.
he has filed an affidavit today,
Not on
same is not on
I
record.
filed it yesterday.
File it yesterday, same is not on record. Yesterday, that is on such and such, same is not on record. Registry to take this, take the affidavit on record and list this matter on, give it.
Lordship, I have to obtain instructions. Only
Forget
few
about.
minutes, Lordship.
List this matter on 28.
There is some urgency, Lordship. Last
Uh,
location also. my senior is in-
List this matter, leave this matter on 13th of, leave this matter on 7th of August.
Okay.
Yes, yes, Goswami. Allow this petition.
Lordship, I have filed an affidavit, Lordship. and
Or is your affidavit?
Filed by Lordship.
Where is your stand? Tell us.
Can you see the page 32, annexary,
Yes,
our affidavit, Lordship.
page 32.
I directed the issue of IMFL on license of non-binding district is hereby stopped.
Paragraph,
There is a annexation.
page 32.
Lordship,
There is no 32 page in this petition.
in the affidavit.
There is no affidavit.
Affidavit filed by the deputy commissioner, superintendent of excise.
This is writ petition. Writ petition, how many annexes, Mr.? Writ petition up to 26.
Yes, madam.
Thereafter, no affidavit. It is stated that who has filed affidavit?
Superintendent of excise,
Superintendent excise has filed an affidavit. Same is not on record. Registry to verify, comma,
In fact,
take,
I have filed reply to that also, madam.
file an affidavit. Spencer. This is item number Atul Bushra, isn't it?
Yes, yes, yes.
madam. It is submitted by Mr. Khatania that he had also filed and reply to such affidavit. Both these affidavits are not on record. Registry to verify, comma, take the same along with the record and list this matter on 7th,
Yes, madam.
7th. Hearing concluded, judgment reserved. Not possible. Otherwise, we thought that we'll finish it up. It's not possible.
operative portion.
Operative portion is difficult. Then it's a whole headache. Yes. We do not know. We do not know what operative portion. List this matter, saving. Hearing concluded, judgment reserved.
Oh, my God.
This,
Can I call Mr. Das, my lord?
this petition, call it
He is probably outside, my lord.
31/7. Order on first paragraph. Second paragraph. Third paragraph আরম্ভ হবো। At that stage, in a past tense হয়ে যাব। attested, Mr. the council submits that. It will have a submission that. Yes, Mr. Das.
Instructions which I have received just now from. Also, we have done many communications with the concerned deputy commissioner. This is not the new dike lordship. This is the existing dike lordship. Yesterday also, he had written one letter to the deputy commissioner. If your lordship permits me, I can read out the letter because I have received.
Okay, come, French. In the aforesaid backdrop, where is that order, Ms. Burman? We sought for instruction. Obtain instruction. In the aforesaid backdrop, the in the aforesaid backdrop matter was adjourned. This we have already dictated, na? This first dictated. Actually. Therefore, this court is of the prima facie view that the dike was constructed over patta land without following any due process of Land Acquisition Act, though some assessments were made for payment of Zirat. Such course of action is not permissible under law, inasmuch as a right of a person can be taken away with due process by following due process of law, and in this case, the due process of law is Land Acquisition Act. This court cannot be also oblivious of the fact that the construction is having public nature. First of balancing the equity, this court is also of the view that the houses of the petitioner should not be demolished till the next date of listing. First of balancing the equities, it is provided that till the next date of listing, the houses of the petitioner shall not be demolished. Inasmuch as till date, no Zirat has also been paid to the petitioner against those houses. In the meantime, detailed affidavits be filed by the state respondent as well as by the requiring department under what circumstances the dike was constructed and why land acquisition process were not followed. Full stop. And if followed, the details thereof. Full stop. List this.
Once then has been-
That is it. Let him have. Accordingly, list this matter on 3rd of September 2024. The communication addressed to MS M. Bormon by the Additional Deputy Commissioner and CO DDMA Hailakandi, along with the annexures therein consisting 4 pages are kept on record and marked as document X.
Go through the letter which I have just produced before lordship because. After
You file an affidavit.
I have.
No, that print out. Just he has given a print. What is that?
For your lordship only.
No, this is the Meghali Burma. Oh, this is. That's why we said, taking note of public interest, don't demolish the house.